Neil Miller, California Society for Acupuncture and Asian Medicine. Boy, am I happy to have this on the agenda. I first brought this to the board's attention about 10 years ago. And my question to the board at that time was, there's a new term out there in the public. It's called dry needling. My question to the board was, is dry needling acupuncture? The answer from the board was yes. And there was no need for any further action. So I'd like to make sure that, that the board is still in agreement, and we ask our professional members, dry needling is acupuncture by the definition of acupuncture. Am I correct? Wow, that's silent.
You're not allowed to respond to public comment.
You're not allowed to respond to public comment? Okay. Can I ask legal counsel a question, and she can respond?
Okay,
well, on here it says that the agenda is discussion of dry needling or unlicensed as opposed to and. So can I assume that it's and I could talk about discussion about dry needling?
Yes, you may
one or the other. Okay,
no,
so
yeah, both.
There's no need to get sued or anything, but I just wanted to know, I mean, I believe that the purview is both protection and informing the consumer, being an informant to the consumer of what our scope is and what we're allowed to do. That's still within the purview, right? Informing the consumer. So if a consumer calls and says to the acupuncture board, is dry needling acupuncture and is it in the scope of practice of an acupuncturist? The answer would be yes. I believe that it would be yes. I don't think that there's a court that would find that I'm out of my scope of practice for practicing dry needling. So I think that is, you know, rather than think about what the physical therapists are doing, I mean, if they're going to get licensed in California, then they'll go through the legislative process and you can comment then and the associations can comment then. But as it stands in California and what your purview is,
10 seconds.
For clarification, dry needling, it's not a CPT code. There's no such thing really. You know, there's no procedural code that exists in America or anywhere for dry needling. There's no procedure code for it. So physical therapists have bypassed their legislative process in various states, and there's a lot of lawsuits, but they bypassed the legislative process stating that dry needling is a form of manual therapy, and they've been billing under manual therapy, not acupuncture, and that's the slippery slope that they have been on. But I just want to talk about what we're doing.
We appreciate it. You're 10 seconds over.
Ron Zeidman said I could have his 2 minutes, if that's okay.
Kelsey?
That's your discretion. You've said
Okay, we'll allow it.
Thank you.
2 minutes.
I have asked this board on several occasions to put on the agenda the return of the Consumer Guide to Acupuncture. You have to go online to find it now. Ben knows that it existed for quite a long time. I was actually quite instrumental in putting that together. And in there, when it talked about Asian massage, it also listed what Asian massage was, and it listed it as manual therapy. And so when you're talking about an acupuncture and you're going to discuss it with the consumer, it would probably be within the purview legally to say that acupuncture is, dry needling is considered acupuncture by definition of what acupuncture is. You're piercing the skin and you're doing this. You're using physiological terms as opposed to talking about yin and yang and qi and those sorts of things. But it is within the licensure of the acupuncture. It is consistent with legislative intent, and it would solve a lot of problems for the acupuncture board to put it in their Consumer Guide of Acupuncture that, yes, dry needling is acupuncture, and we've taken a look at this, and we see no difference. An acupuncturist is not beyond their scope of practice because acupuncturists are now advertising that they do dry needling as one of the styles, like saying, I do Korean acupuncture, I do 5-element acupuncture, I do neurophysiological acupuncture. I mean, neurophysiological acupuncture doesn't exist in scope, but it's quite legal. Just as the term dry needling has made it into the nomenclature, the AMA has made a comment on it. It's pervasive within our community. When I first brought it to the board's attention, it was in no scope of practice. I believe it's in 26 scope of practices now. And if they want to do it in California, there's a legislative process that they could do that, and that's not for this board. But I would like to be clear that when I say to someone, they ask me, do you do dry needling? I say, well, yes, that's acupuncture. So dry needling is acupuncture, and that's the mantra that I'm going with, and I just want to make sure that I'm consistent with the board and with the law.
Great. Thank you, Neil. Anyone else?
My name is Lily Huang. I'm representing American Society of Chinese Medicine. Everybody have spoke a lot about dry needling. I just want to give you a little history background. The reason dry needling is here in America, it is being publicized, is because of small group of greedy people wants to make money out of it. They put together CE classes to train, because they cannot make money out of acupuncturists, because this is just part of acupuncture. They're taking a little bit of acupuncture and try to put it, call it dry needling, and solicit physical therapists to grab on something very effective and economically valuable, and then have them do it, and then they're making money out of this. And this is the reason how it all started. So for the protection of the Chinese medicine and acupuncture, for the protection of consumers and protection of just human morality and ethics, this needs to be stopped. The Attorney General from New Jersey have made a statement that dry needling is part of acupuncture. It should not be practiced without license of acupuncture, and should not be practiced by the physical therapist without the training of acupuncture. So I'm asking if the board can make a statement to take a proactive position to issue a statement that dry needling is part of acupuncture, and whomever wants to do it needs to have an equivalent training, just like a licensed acupuncturist. Thank you very much.
Great. Thank you. Oh, it's okay. And then she'll come next.
My name is Asha Huang. I just present myself. I've been, can you hear me? It's work. I've been practicing acupuncture since 1997.
Can you say your name one more time?
My name is Asha Huang.
Thank you.
Just present myself. I'm so impressed and appreciate the what's the name? Yeah, it's good. Can make a clarify for the regulation and the authority for acupuncture license. What's the meaning of the details? I think I also understand Jeannie. Yeah, she mentioned about the role, the board, how the role board can play, how in between for the situation. But I believe now for California residents or even acupuncturist, how many people totally understand the regulation and the current regulation and the law we already have? I believe very small people, group people, they know that, not everybody. You know, actually, I've been in practice for a long time, but a couple years ago, for some reason, I done some research. I just got to know the regulation authorities. So I recommend one thing is very important. I believe stop the people their practice acupuncture without license is protect consumer. This the role is the board, acupuncture board should play.
10 seconds.
No, yeah, based on the current existing authorization and the regulation, the law, board should play the role, stop anybody within the license practice acupuncture, whatever they call the dry needle or any other name, or called dog or called cat, whatever. I think board have a responsibility, obligation to play this role to stop anybody without license to practice acupuncture. Okay, and another one.
I'm sorry, Matt. You passed.
Okay, board would help to educate public and acupuncturists. Everybody can know, understand more.
10 seconds, Matt.
Yeah, regulation and law, and for some make a strong a comment or not sufficient statement. Let the public speak, make a voice to let the public understand, educate, and understand what's happening there.
Great.
Then that could avoid a lot of misunderstanding, avoid further issue. That's my point. And
Ma'am, I'm sorry, we have someone right behind you. You've passed your time. You're at about 3
okay.
minutes now.
Thank you very much. Okay.
Thank you. Oh, I'm sorry, Jacques. Was there a woman, another woman in front of you? Yes.
Good morning, everyone. My name is Jun Jie. I'm an acupuncturist just behalf of AACMA. And I heard about dry needle like this. You guys already did a lot job. But another thing is for prevent, for future, our state is safe. We all feel like this. But I think maybe I just recommend our board can put the dry needle is the acupuncture for the education, the future acupuncturist like student. So that will be good for prevent and the future if other states come to like a dry needle is legal to come to the United States. And also, I wondering if, like other states can practice, like put the dry needle as legal. So, I just think like piercing also can legal to do acupuncture. Don't you think like that?
Right.
Yeah. Okay. Thank you.
Thank you. Jacques?
Jacques Marco, Empress College, Santa Monica. I just wanted to put it into an historical perspective. We all are aware of it, but let's just review it. Dry needling is a derivative of wet needling that was all developed by Dr. Travell, who happened to have been the physician of JFK, John F. Kennedy. She did wet needling, which was injection therapy on the trigger points. So these trigger points were Asher points and were described by Sun Si Miao over 1,500 years ago. He lived 581, 682. So it's nothing new. It's just being hijacked, the word Asher to trigger point. We all know that. I'm sure Dr. Geronimo has studied as well as Dr. Chang. So it is just been hijacked. The term has been hijacked. Thank you very much.
Still, good morning. Good morning. My name is Geronimo, the president of American Society of Chinese Medicine. I'm here is because I heard the board. One of the board the duty is to protect the consumer. So we should see what has happened in California. Acupuncturist is also in the work compensation is a physician, but the physical therapy is because of training. Okay. I think you should treat the Chinese medicine as a medicine. So all the people want to do that, they should have proper training that is to protect consumer. As the board duty, you have the duty to protect the consumer. So I think you should think about the dry needle and the acupuncture, it's the same or not. So I think the board should give a position. What do you think about the acupuncture treatment and the dry needle? This is to show you protect the consumer. Thank you.
Great, thank you. Any other public comment?
I have a procedural question.
Sure, Neil, come on up. Well,
I'll just make it very brief. If there's something on the agenda, they go to public comment, and there's a comment.
Yeah, you got to sit down. Yeah.
Neil Miller, California Society for Acupuncture and Asian Medicine. If there's something on the agenda and the board discusses it and they go to the audience and there's a comment from the audience, can the board amongst themselves, if somebody made a comment and they said, wow, that's an idea, can they discuss that idea, or can they take action on something that was thought of in the room, but it's on the agenda and they can make it a statement or do something of action regarding something that's on the agenda? In other words, if somebody in the audience had a great idea and they thought it was a great idea, could they then say, well, I think this is a great idea. I'd like to make a motion that we do X, Y, Z based on something I heard today, whether it was in your discussion or with discussion with us, if it was an agendized item.
So
Thank you.
Is that something the board would like me to answer?
Please.
Okay. the board may discuss things that are agendized, and the board may discuss anything that, is relevant to the agendized item. In terms of action items, the Open Meeting Act is very specific that you should, if there are going to be action items versus discussion items, they should be agendized as such. This particular item has been agendized as a discussion item. So if the board did want to take action, we could have that discussion. But however, I would advise that it is a discussion of dry needling or unlicensed individuals applying a needle to the human body, and it was not agendized as an action item.
Could they discuss if there was something that came out of the audience that was not discussed by the board that gave someone on the board a great idea, and they could discuss it, and then someone here could say, let's put that on the agenda. I'd like to have this on the agenda for this or that. In other words, can they then discuss something that was said here
There's
amongst themselves?
There's a section, again, sorry, is this something that the board would like me to answer? Okay. There is a section for future agenda items, so any board member at that time could bring up a future agenda item. And,
Right.
yeah, okay.
And then that's at the end.
procedure.
Right.
Yes,
Yeah.
that's number 17.
Okay. Good news? Okay.
Thank you.
Any other public comment? Seeing none, I'd like to bring it back to the board. And I'd like to offer up a suggestion to the board. Considering everything we've heard from the public, from our legal counsel, from our executive officer, that we continue to monitor the issue and let legal counsel do its research and come back to the board. Agreed? Okay. Great. So we are going to break for lunch a little bit early. So it is 12:16. We will start at 1:01, directly at 1:01. So if stuff's going on, be here 5 minutes before because we'll start right on time, guys. Mind you, people have flights. We want to make sure everyone gets out on time. Great. Thanks, everybody.
And also,
Ben, go ahead. Board members. Kelsey, are you ready?
Yeah.
Okay, so I'll call the meeting back to order at 1:15, and we are going to move to item number 9, presentation regarding how to conduct a meeting in accordance with the Bagley-Keene Open Meetings Act.
Okay, good afternoon. Again, second presentation of the day. This one is on the Bagley-Keene Open Meeting Act and how to conduct a meeting in accordance with it. So I'm going to start with the purpose of the act. I've provided everybody a handout, a little one-sheeter, and that's kind of how I'm going to guide my presentation. The purpose of the act is, it's under the government code. And 11120 says, it is the public policy of this state that public agencies exist to aid in the conduct of the people's business, and the proceedings of public agencies be conducted openly so that the public may remain informed. The people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know what is not good for them to know. The people insist on remaining informed so that they may retain control over the instruments that they have created. So essentially, the Open Meeting Act is there to govern how you conduct business and when you can conduct business. And there are 3 basic principles that the Bagley-Keene Open Meeting Act sort of impose upon boards. And the first one is that you give adequate notice of meetings that will be held and items to be discussed. The second is that you conduct board business in an open forum, except where closed session is statutorily permitted. And the third is that there be the opportunity for the public to comment. So, on the first point, adequate notice. So that's where the agenda comes into play. The Act provides that the boards must provide written notice to requesters as well as on the internet at least 10 days in advance of the meeting. And Teleconference also have the same requirements, but also that the items on the agenda must be detailed and itemized and identify all business that's going to take place at that meeting. And sort of the rule of thumb is, and what I always ask Ben when he sends me an agenda or whoever, is can a reasonable person who's looking at this understand what the board is going to be doing, what they're going to be talking about? Because that's your invitation to the public to say, here, we're going to be discussing this. If you would like to show up, please do. And this is the notice that we're giving you. So, excuse me, so it has to be specific enough that somebody who wants to come and listen to this topic knows that it's going to be discussed. And so I know sometimes I jump in and say, let's not discuss it because it's not what's on the agenda. And that's the reason for it. Because if you talk about something that's not on the agenda, then you are not affording the public the opportunity to engage in that conversation as well. And so that's why the Open Meeting Act does not allow for items that are not specifically addressed on the agenda to be discussed or to be acted upon. That's why there's the 10-day notice, and so that everyone is aware and that the public can participate. So a little bit about teleconference meetings. They also have that same notice requirement. They also have to be noticed 10 days in advance. They have a few special requirements that all teleconference locations also need to be noticed on the agenda, and that at each of those locations it needs to be open to the public. So it can't be, you can't sit in your car and participate in a teleconference meeting. Well, I wouldn't recommend it.
So
Yes.
Question about that. So if there's a teleconference call, say in LA, and we've designated that as a site, so you're saying now that, because we've thought about this before, if we're on our way there, we can't jump on the phone and call into the conference line?
No. So the location has to be open to the public and a board member has to be there. So we would have to wait. We wouldn't technically have a quorum, or we wouldn't technically have you at that place. And so that's the risk of teleconference. Teleconference can be a very great tool for boards to meet when they don't have a regularly scheduled meeting where they can't get everybody in one location. They can be really great for that, but it's also a risk that if somebody doesn't show up to their location, you cannot have that meeting. So
Conference has a specific address, so he wouldn't be able to be in LA, but have, let's say, Hildy there.
If Hildy was there, yes.
But he could be on a speakerphone in his house, conferencing in?
No, I'd have to be physically there.
Yes,
Correct.
yes. Okay. So, so anywhere that a board member is at, it has to be a public location, and it has to have been noticed. So,
Being on a phone is a site, and it's not noticed.
right, exactly. So you driving somewhere, your location is constantly changing. We didn't notice that. If you were meeting with another board member, let's say at that LA location, and they were there, then we could start the meeting, and then you could jump in, if we have a quorum. But yes, so that is the risk of a teleconference meeting, is that if someone is not at a noticed location, the meeting can't go forward. The kind of exception to that is that you can have a staff location where you just have staff, for example, in Sacramento. And we suggest that you also just notice that so that people know that a board member will not be present. It'll just be staff at that location. I want to talk a little bit about serial meetings and communications via electronics means too, because the Act defines a meeting as basically any time that a majority of members get together and conduct board business. And a majority is a quorum. For purposes of your board, under 4933, Business and Professions Code 4933, a quorum for you is 4 members, which includes 1 licensee. But it can also mean a committee, which can be comprised of a number of different board members, so it would be a majority of a committee, or a task force. So the rule is generally 3 board members can constitute a task force or a subcommittee, and those need to be noticed. And so that it also applies to any electronic communications using the telephone or email to conduct board business to circumvent the Open Meetings Act. That is also prohibited. And then serial meetings, where that is where board members conduct business, a majority of board members conduct business by using a point of reference. So, for example, if everyone were to call Ben and say, let's do X, Y, Z, and Ben turns around and calls the next person, and everybody's using Ben as a hub, then that can be considered a serial meeting and in violation of the Open Meeting Act.
Would it depend on if it's an agendized item, or is it just talking about?
It's just board business.
Okay.
So if you're conducting board business, it needs to be noticed and agendized. So,
What, it was like a date or something?
well, there are certain exceptions, right? There are certain things that they don't consider board business, and the Open Meeting Act does spell those out pretty well. And anytime there's a question on that, certainly come to me and I can flesh that out for you. You know, if for example, I believe one of the exceptions is if board members go to some sort of forum,
Right.
you know, some sort of acupuncture symposium, and you're there as board members, you can do that. You don't have to notice that because you're not necessarily conducting board business. You're just there to observe.
Tell me if I should bring this up in another part of your presentation or not, but from previous notification to us, we were advised, like when we're invited to some celebration of some sort by an organization, we were advised to be very cautious of attending due to if there's other board members and there's more than 2 or 3 board members, and that can cause a perception problem. Like we were just given a invitation to a celebration in March or something. What is the advice to us as far as attending? I mean,
So in terms of, and I'm more than happy to go into specifics offline and stuff like that and go into specific details. But the general rule of thumb is that, again, if you're conducting board business, if there's the opportunity to conduct board business, that is prohibited. So if you're not conducting board business, if you're just there as individuals and you're not discussing anything board-related, it doesn't come up, then it would probably be not a violation of the Open Meeting Act. But again, I'm more than happy to go into specifics and all that with you offline if you have specific questions or specific examples that you want.
it has occurred previously with this board that there were 2 or 3 members at a celebration and something came up where, because something always is going to come up when you have board members, but they're asking questions to us, you know,
Right.
all the time, and it became an issue. So this is something that I addressed with the previous legal counsel and said, and was pretty stern about making sure that we veer on the side of caution.
Right, right. And again, perception is, you know, sometimes you may not be violating the Open Meeting Act, but you want to perceive that, you know, everything's transparent and all those types of things. So it can be a judgment call on that. But yeah, the rule is conducting board business. So that leads us to our second point, which is conducting board business in an open forum, except where closed session is statutorily permitted. So again, that kind of goes back to the notice requirement, but everything that you agendize and all of the board business, all the decisions that you make as a board should be done in open session in an agendized meeting. There are some statutorily permitted closed session items where the board can go into closed session. Those are disciplinary matters, preparing or approving grading examinations, pending litigation, matters affecting personal privacy, and executive officer appointment, employment, or dismissal. And I think all those are pretty, it's understandable why the board can meet in closed session. Again, examinations, you wouldn't want all the public to know what questions are going to be asked on your examination. You know, those types of things can be done in closed session. And then recently, the Open Meeting Act was also amended to include a roll call vote. So now when you're conducting business and you have a motion on the table, it is now required that it be a roll call. And so all persons, well, it's required that all persons in the minutes be recorded how they voted. So the easiest way to do that is a roll call vote. And the last task that's imposed via the Open Meeting Act is provide the public an opportunity to comment. So that's why on every item there is the opportunity for public to have input, because really that's the whole point of this, is to be able to invite the public and hear their opinions. The general rule is that public comment must be allowed on open session agenda items before, during discussion of each item, and before a vote. There's one exception, excuse me, and that is if the public was provided an opportunity to comment at a previous committee meeting of the board where the committee consisted exclusively of board members. If the item has been substantially changed, then another opportunity for comment must be provided. So that's the only exception to that one. And that's why you always see me pipe up and say public comment, you know, even if there is none, we just want to make sure that we always give the opportunity. And so for public comment for items not on the agenda, that's sort of a separate issue. And the law prohibits the board from substantially discussing or voting on any matter brought up during public comment for items that are not on the agenda. And that is because the board hasn't given notice of those items. And so they can bring them up at a future date. But to engage in discussion or to actually take any action is prohibited because, again, the rationale being that while someone from the public is bringing it up here, there may be others from the public who wanted input and were not afforded that opportunity because they didn't know that this was going to be brought up. So that's why sometimes I'm the fun police and I limit conversation. And it's not because I want to be the fun police, but it's because it really is for public protection. We want the public to be able to know what the board will be discussing and to show up if they so choose. Another reason that I'm sometimes the fun police is that the Open Meeting Act actually makes it a misdemeanor to violate the Open Meeting Act. So they take violations obviously very seriously. And so that's why I'm here to caution you as board members so that there is not a violation of the Open Meeting Act. Are there any questions?
Yeah, can you go into a little bit more detail about the power of what was it? They call it the power of two or the rule of two?
The rule of two? So, okay. So generally speaking, if you conduct board business, it's a majority or a quorum. But the Open Meeting Act defines committees or task forces as two or more when they are, and there's a couple of ways that they can be formed. They can either be formed by the board, they can either be formed by a board member, or if they're tasked with doing something for the board, tasked with official board business. So in that sense, if it is 3 people or more, then it has to be noticed. And even then, it doesn't necessarily have to be all board members. It can be more than 3 people. If it can just be 1 board member and 2 public people. It really depends on the situation. If they're tasked with doing something for the board, for board business, or if they're conducting board business, or if they've been established by the board, or they've been established by a board member. So that is the rule of 2, that you're not violating the Open Meeting Act if just 2 people are meeting and conferring. That's an ad hoc committee. We most of the time call them ad hoc committees. And so that's a way for, 2 board members to get together and research something to bring to the full board later on. And you don't necessarily have to notice those meetings, but when it becomes 3 people, it does become a meeting.
Is that the 3 board members together as considered open meeting?
Yes, so that could be considered a committee or a task force. Mm-hmm. Yeah.
So is that if the board member with the public member talk something is not open
I'm sorry, I can't hear you.
If the couple board member
Mm-hmm.
and also with the public member,
Mm-hmm.
I mean, and talk something, is it considered open public meeting?
Yes, so it does not, the Open Meeting Act does not differentiate between public members and licensee members, if that's what you're asking.
I think it was two board members and a member of the public.
Oh, okay. So if it's two board members and a member of the public, just a general member of the public, generally no. However, if it's a committee of sorts, so if it's been, if the board has asked these two board members and a member of the public to meet to conduct board business, then it does need to be noticed.
Okay, thank you.
Mm-hmm.
Can I follow up on that? So what if you have a,
Board member questions only? No,
Oh.
I'm just kidding.
I respect the process.
No, I'm just kidding. Yes, sorry.
Let's say you have a board member and a member of the public, but doing some research, so that's ad hoc, that seems okay. But now you want to get two board members together. That same board member that did research is now meeting with another board member. Would that become serial because they're taking that research and now discussing how to bring that information?
It could become a serial meeting, yes, because for serial meetings, again, you're conducting a meeting through a centralized point or a central person or something of that nature. So you're, just because you meet kind of individually, if those ideas are then brought back and, for example, one board member does research, they come back and they meet with two other board members and say, oh, well, this other board member said this, that, and the other, and we should do this, then yes, that's become a serial meeting because they're conducting board business by way of sharing that communication.
Yeah, that's a serial meeting,
Yeah.
So ideally, if you're going to do anything, talk with two people.
Ideally, if you want to do anything, just run it by me, and we'll discuss the details. But yes, so and again, I don't want to confuse too much on having non-board members a part of it. That only really comes into play if the board has created a special task force that includes a member of the public, or a board member has asked a member of the public and two other members to join them, or one other member to join them to do board business. So it's very specialized situations. So it's not every situation where there's three people. But I do want to bring it to your attention that there are situations where somebody that's not a board member can be considered in that rule of three.
So bottom line, keep it to two.
Yeah. Keep it to two. Ask your legal counsel. We'll walk through it and figure it out.
Or just don't talk to anybody.
Jamie has a rule of one.
When I first started, I did. So really paranoid.
But no, I mean, ad hoc committees can be very useful to boards, and so I don't want to scare everybody out of that, but they can be very useful. But just make sure that you run it by your legal counsel to make sure that you're in compliance.
Are we good? We're good? Great. Any public comment on this topic? Neil?
Only by yourself.
Neil Miller, California Society for Acupuncture and Asian Medicine. I know that you have 10 days, and that's the law, but if at all possible in the future, not waiting to the last minute so that we have 10 days' notice. In other words, if we have more than 14 days' notice, like today it cost me $500 to fly up here because I just heard about what was on the agenda within 10 days and I couldn't get a cheap flight. So it would certainly serve any consumer or anybody else who would like to attend the meeting. You might have a better attendance if you can get us 18 days, say. So it gives you 4 days from the notice to try to make an appointment, plane flight to get here or someplace else.
Seeing no other public comment. Thank you, Kelsey.
Mm-hmm.
Thank you.
Okay, everyone, we're going to move forward to item number 14. consideration and possible action on proposed amendments to Title 16 CCR Section 1399.469 Disciplinary Guidelines, and I'll let staff walk us through that.
Okay. Jamie, board members, this is an issue that has been on our radar, as you know, for quite some time. I won't get into the long history of revising our disciplinary guidelines and intermixing our revision of disciplinary guidelines with our uniform standards and everything in between. But suffice it to say, after a lot of hard work, this is where we are now. We have updated our disciplinary guidelines, revised December 2016. Basically, I'll just kind of review it real quickly. The memo that we're going to be presenting, which Christine will talk about, she's going to review the changes to the guidelines themselves. In a minute, I'll just refer you to the text and read that to you for your consideration. Basically, the guidelines are used by attorneys, administrative law judges, licensees, others involved in the disciplinary process, staff itself. We use these regularly. Enforcement uses them regularly. It is what we use to discipline licensees for various violations of the Acupuncture Practice Act. The current guidelines are very dated. They date to 1996, they need to be updated. This is something that I believe is our strategic plan to do. So it will be something that we will get done. In December, the board's enforcement committee reviewed the guidelines. We reviewed them quite thoroughly and had requested a number of changes, as well as some the possibility of some alternative language, which we did, and we have made some of those changes. We also have some other changes which we felt we maybe didn't really want to go forward with as a recommendation, but of course it is ultimately your decision as the board if we want to add that in or not, and we will be discussing that when we start reviewing the guidelines themselves. And because this is a new regulatory package, if it's passed out today, it will be subject to the normal 45-day comment period. So if the guidelines pass out today, we will begin to build the regulatory package, and then we will get it through its normal approvals. DCA has a process now where we have to get the initial statement of reasons, the notice to the consumers, et cetera. They have to review and approve those documents before they get posted on, given to and posted on the Office of Administrative Law's website. So we will go through that process, and then once that's done and it's posted, we will have a 45-day comment period. If we receive comments like we have with other packages, we'll bring them back to the board for the board's consideration, and then we'll move forward from there. So that's kind of the overview of what we're doing, and Christine's going to take us through the actual changes themselves. Now, real quickly, let me have you, I'm going to refer you to, if you go past the memo, it's agenda item 14C, pardon me, 14B is the actual language that you will need to approve or deny. And I'm just going to read it out loud real quickly, if I may. Everyone have it? It's after the memo.
In the middle.
Yeah, right in the middle, agenda item 14B behind a pink sheet. It's just a one-page little paragraph there. Okay?
Got it.
Okay. Basically, we're going to be amending California Code of Regulations, Section 1399.469, Title 16. And the language will say as follows, 1399.469 Disciplinary Guidelines. In reaching a decision on a disciplinary action under the Administrative Procedure Act, Government Code Section 11400 at sequence, the Acupuncture Board shall consider the disciplinary guidelines, and this is in strike-through, so we'll be removing this, Department of Consumer Affairs, Acupuncture Board Disciplinary Guidelines, stricken is 1996, and the current one, which references the current one, which will be considered today, revised December 2016, which are hereby incorporated by reference. Deviation from these guidelines and orders, including the standard terms of probation, is appropriate where the Acupuncture Board, in its sole discretion, determines the facts of the particular case warrant such a deviation. For example, the presence of mitigating factors, the age of the case, evidentiary problems. So really, it's our existing language that we've had in place for quite some time. The only change is just instead of the Department of Consumer Affairs dated in 1996, it is now Acupuncture Board Disciplinary Guidelines revised December 2016. The regulation has to specifically reference the document we're adopting and what its proper title is. So obviously the proper title is Acupuncture Board Disciplinary Guidelines revised December 2016. Okay? So that's the language we'll be considering, and we can go through this. Let's go through the changes.
Okay, so as Mark stated, we went through all of the changes at the Enforcement Committee, so I'm going to defer to Jamie and the board. Let me know if you want me to go again through each changes of the memo, or if you want me to just address the requested changes that the committee and the public comment raised at the Enforcement Committee. If you want me to just address those.
Yeah, let's go through those, the ones that
Just
were
do that,
addressed.
isolate, okay. So there's a memo that is not in the board packet that I handed out, and it's addressed to you from me, Christine Brothers. So the subject is addressing the Enforcement Committee's requests regarding the proposed Acupuncture Board Disciplinary Guidelines revised December 2016. Oh, sure, sorry. Move it closer. So I'm just going to go through, there's just an itemization of each area that the committee made a comment or the public did. So the first one was in regards to the psychological evaluation probation term, which is page 7 of the actual disciplinary guidelines document, and included the proposed language there. And the actual comment from the committee was requesting that the addition reference for the Diagnostic and Statistical Manual of Mental Disorders, DSM, be restored, and for the current edition to be included. Our response, staff's response and recommendations, we restored the edition reference and updated it to the current 5th edition. Number 4, the practice billing monitor probation condition, pages 8 through 10 in the disciplinary guidelines. The committee requested that the qualifications of the practice billing monitor be refined, specifically by adding that the monitor shall have experience for a minimum of 2 to 5 years. Staff's response and recommendations. Staff evaluated the pros and cons of adding a minimum level of experience for monitors and determined that doing so would be too limiting. Through staff's experience as probation monitors, it is sometimes better to have more flexibility and discretion as to who is qualified to serve as a monitor. In addition, the education and training is fresh for newly licensed acupuncturists, an attribute that may serve the board just as well as someone with more experience. Therefore, it is staff's recommendation to not include a minimum level of experience for practice billing monitors. Also, as a procedural question, do you want me to pause at each comment in the recommendation, and do you guys want to?
I think it'd probably be better if you went through all of them.
Okay.
Board members, just take note of which items you have questions about, and then we'll go back to them. So.
Okay. So moving on, probation condition number 10, alcohol and drug abuse treatment program, page 12 of the disciplinary guidelines. The committee requested that the part of the condition that requires the respondent to submit proof of completion of the recovery program to the board or its designee within 15 days of its conclusion was not clear enough. The committee had also suggested that the respondent be required to submit proof through certified mail. Additionally, the committee wanted staff to research other boards to see how they state documents shall be submitted and how the deadline is specified. This was a comment to address how this is stated throughout the guidelines. So anywhere we refer that in a probationary condition that a respondent needs to submit something within so many days. Staff researched 7 other healing arts boards and found that the current proposed language of how a respondent must submit a document related to a probationary requirement is consistent with how other boards phrase it. If the probationary condition gets too specific in how a document is submitted, it can be too limiting for the business process of the probation program. In addition, staff is required to put respondent on notice of each violation. This may be burdensome for staff to track and address each probationer's failure to submit a document in a particular way. Currently, staff can assess whether there was a violation of the deadline based upon the postmark date, date of fax, or date of email. Staff recommends that no changes be made to the proposed language in condition number 10 regarding the submission of proof of completion or anywhere throughout the guidelines where submission of documents to the board is required. Probation term 11, attend chemical dependency support and recovery groups. Page 13 of the disciplinary guidelines. This was a public comment. A public comment was made suggesting that condition number 11 be amended by specifying 12-step groups, or 12-step programs in lieu of using the term chemical dependency support and recovery groups. Staff recommends that no change be made, since requiring 12-step programs may be too limiting to probationers. Using a more broad term of chemical dependency support and recovery groups allows probationers the ability to choose a program that best suits their needs. This will in turn promote compliance and a willingness to stay on a path to recovery. Additionally, examples of 12-step programs such as Alcoholics Anonymous and Narcotics Anonymous are provided as examples in the probationary condition. Probation term number 12, abstain from drugs and alcohol and submit to tests and samples, pages 13 through 14 of the disciplinary guidelines. The committee requested that the references to the California Uniform Controlled Substances Act and Dangerous Drugs list be restored and the codes be updated. Staff restored the references and updated the applicable codes. Public comment was also made suggesting that the probation condition should use the term medical provider instead of licensed practitioner when referring to respondents being lawfully prescribed drugs as an exception to abstaining from drugs. Staff recommends that no change be made since the licensed practitioner is already defined as someone who can lawfully prescribe as part of a documented medical treatment. Staff thought the use of medical provider may be too constricting since there are other types of practitioners who can prescribe other than medical doctors or physician and surgeons. Number 13, coursework probationary condition, is page 14 of the disciplinary guidelines. The committee requested that more research be conducted into alternative language other boards have in use. Specifically, the committee had issues with there not being a range of hours specified in their probation condition. Staff researched 7 other healing arts boards to see how each board's coursework requirements read. Research shows that boards do it all different ways. Some boards identify the actual number of hours or leave it a fill-in field for it to be determined by the administrative law judge or in settlement negotiations. Other boards have several different coursework conditions on each coursework area, specifically an ethics course terms or a medical record-keeping course condition. Several boards leave the coursework area and number of hours unspecified, allowing the board or its designee to notify respondent when his or her probation begins. Staff preferred the latter option because it allows staff who know the case best and who know available coursework options to set the hours and course content areas. This ensures that coursework is assigned on a case-by-case basis. Staff recommends that the proposed language for condition number 13 as proposed above be accepted. This is actually new language than what we had brought to the committee. So you just want to review that. And it was based on our research. Okay. So condition number 15, supervised practice, pages 15 through 16 of the disciplinary guidelines. This was a public comment. A public comment was made requesting that the qualifications of the supervisor be strengthened, specifically by adding that the supervisor shall have a specified minimum years of experience. Staff evaluated the pros and cons of adding a minimum level of experience for supervisors and determined that doing so would be too limiting. Through staff's experience as probation monitors, it is sometimes better to have more flexibility and discretion as to who is qualified to serve as a supervisor. In addition, the education and training is fresh for newly licensed acupuncturists, an attribute that may serve the board just as well as someone with more experience. It is staff's recommendation to not include a minimum level experience. And this is similar to the first term that we discussed, which was not that one, sorry. The practice billing monitor, which we also recommended to not have a specific number of years of experience. And then the number 25, probation monitoring costs, which is on page 19 of the disciplinary guidelines. And this is also new language from what we brought to the committee, because the committee requested that more research be conducted into alternative language other boards have in use. So we researched 7 other healing arts boards. Since staff currently does not have an accurate tracking method for tracking hourly costs, language that was more general was desired. Staff found that a combination of language from Pharmacy Board and the Medical Board best suited the board's needs and current process. The board currently only collects probation monitoring costs if travel is conducted for interviews and probation reviews. It is believed that the old language from the 1996 guidelines included hourly costs for reimbursement of probation monitoring because the board used to have the Division of Investigation conduct all monitoring. This is no longer the case, but since the board ideally would like to have a dedicated staff person for probation monitoring and has pursued such position through last year's budget change proposal, board staff would like to retain the ability to collect reimbursement of the costs associated with probation monitoring. Staff recommends that the proposed language for condition number 25, as proposed above, be accepted.
Great. I want us to move through these sequentially, and Kelsey, please let me know if I'm out of order in terms of what we're doing here. I like us to go one by one to ask if the board members have any comments or questions per item.
Although I do just want to point out that since the committee had been the only entity to approve the disciplinary guidelines, I just want to make sure that the board members that were not on the committee or were not there, that the committee met, have had a chance to look over all of the changes, because the board as a whole needs to approve the document as a whole going forward. So however you want to conduct that,
okay.
I just want to make sure that the record reflects that all board members are aware of the changes that have been made, approve them, and don't have any other suggestions for any of the other language as well.
Great. So we can go through each of them with the board and have public comment afterwards, correct?
Mm-hmm.
Okay, perfect. Okay. So what I'll do is, just to move the meeting forward, I reserve the right to amend my motion after we've discussed the issues. So I move to approve the proposed regulatory text for CCR section 1399.469 and the proposed Acupuncture Board Disciplinary Guidelines revised December 2016 as incorporated by reference, and delegate the authority to the executive officer to make any technical and non-substantive changes that may be required, and to adopt the proposed regulatory changes. Do I have a second?
I'll second that.
Great. So we'll get started on discussion now. So we'll start with number 2, board members, psychological evaluation. Any comments or questions for staff regarding this? Number 2.
Jamie, would it be helpful to actually start at the very beginning, because we did change the introduction, the general consideration, terms and conditions. Those are changes as well.
I'm looking at the document that Christine provided.
Okay.
Oh, he's just explaining.
Oh, yeah, so sorry. That's my what I was talking about earlier. So the committee approved the other language and made some recommendations. So those are the changes that Christine just addressed. However, the full board needs to approve all of the text, not just the changes that the committee did. So however you want to do it, if you want to take up the changes that the committee put forward first, and then go back and make sure that all the language is okay with everybody.
Yeah, so if board members will refer to the memo that's in the actual packet from Mark and myself, that is details all of the changes throughout the entire document, all of the changes that we're proposing.
So, right, proposed changes starting with overall document. Okay.
Yeah.
Okay, so we'll go through every single one, board members.
So you don't need to go necessarily change by change, like we don't need to talk about necessarily in great detail how we changed acupuncture committee to board.
Okay.
But if you just wanted to maybe do page by page and take
Oh,
a look
okay,
and
gotcha.
ask and say if there's any comments or if people are okay with the language or if anybody has any suggestions, that might be a way to do it.
Gotcha.
I'll leave it to your capable hands, but
Okay.
I don't necessarily think that you have to take up each and every.
Right.
I mean, I'm on the committee, and I remember this thoroughly. The only ones that I would want to just go over is the ones that Christine just mentioned, that it was new to us. We haven't heard it.
Oh,
So I would like you to point those out at this point. But all the other ones, you know, we went over it, and we were aware of the changes we asked you guys to look into, so, you know.
Right, but
Right.
but that was
Yeah.
just the committee.
So,
It wasn't the
I-
full board, and
I-
the law requires the full board.
understand.
Okay.
Okay,
Yeah.
so I got it. So what we'll do is everyone follow the memo from Mark and Christine. So what I'll do is I'll highlight the ones that were changed in the other memo, the one we were just talking about. But we'll go page by page, so we're on the same page.
Page of the packet, correct?
Yes.
Page of the packet.
Yes.
Page 2 of the packet,
Yes.
got it.
So we'll start this way. In terms of page 2, board member comments on anything?
No.
No,
Okay. We are going to go to page 3. So number 2 was highlighted as one of the items. Does anybody want to talk about number 2?
We're good.
not my,
Okay. We'll wait a few.
We're good.
Okay. So we'll move to page 4. I'm sorry, let's go back to page 3. So another item that was highlighted was number 4, practice billing monitor. Comments or questions?
I do have a comment on that. In looking at it, I had a couple of questions. And I thought that maybe the board might want to separate practice and billing monitor to be separate, since some boards take a billing monitor and not necessarily use a licensee, but use maybe somebody in like the accountancy world to do it. And then my other question was on page 9. There's a paragraph that says, upon approval of the monitor, it's the second paragraph, upon approval of the monitors, the board or its designee shall provide a monitoring plan. And then it goes on, and then it says, if the monitor disagrees with the proposed monitoring plan, the monitor shall submit a revised monitoring plan with the signed statement. And my question there was, does then the board designee have to approve that, or is that an automatic, does a revised monitoring plan automatically take effect? It isn't clear to me what happens there. So those are my 2 comments on that. And I apologize because I've been doing a lot of disciplinary guidelines with different boards, so I've been gathering a lot of information along the way. And so I just saw that and wanted to call it to your attention.
Okay. Is there possible to get an answer to her question, Christine?
So I think if I understand, you're saying like in the event that we get that approved practice monitor quits and then we approve another one, is that what you were talking about in the process of?
Well, it says upon approval of the monitors, the board or its designee shall provide a monitoring plan.
Yeah.
So.
If the monitor disagrees with the.
In real practice, let's say you have a probationer, so you're going to provide the plan. You, Christine, are going to provide the plan, right? And then, but if the monitor disagrees with your plan, then they submit a revised plan. So my question is, what happens next? Do you have to agree to that plan, or does that plan, the revised plan, automatically become the plan?
I see.
Yeah.
Well, this is new language. We have not used this in our decisions yet. So that is something to think about. Currently, what we do, sorry, let me just look at the language again. Okay, so this is actually in contrast to what we currently do, which we only have practice monitor in our current disciplinary guidelines. But when we see this, we actually require the monitor to come up with the plan proposed plan and submit it to the board or its designee us to approve it or deny it, and they'd have to then change it. So this is different in the fact that enforcement staff would actually be providing the monitoring plan. So if the monitor disagrees with it, this is sort of uncharted territory for enforcement. So that's a good point to bring up for us to figure out how that would play out.
I would think that the probation monitor would want to have the final say in that. Does it work well for you to have the monitor send you a report and then you approve it?
Yeah, I mean, that's what we currently do. We typically actually give them kind of a template of what we've seen. A lot of times they'll just go with the template because they haven't had experience as being a monitor for a practice either. So it's sort of kind of like we're doing that. We're providing the plan. So we never have this disagreement. But then some people do choose to not use the template, which is kind of like a sort of an evaluation chart. Some people choose to just do a narrative. And we're flexible as long as they're just covering the areas of the practice that we want to see. It may be more beneficial if we keep that piece of the language with how we currently have it in our guidelines, because we do want the final say so. So I'm glad you brought that up. So if you look at the, did we include? Yeah, if you look at the stricken language, where does it say it?
What page?
Just right back on page 8 of the memo. You can see the stricken language.
Which pages? Yeah, page 8.
Yeah.
Page that was 3, that's now 8.
Yes.
Correct.
Yeah.
Okay.
I'm just trying to find the part where it says.
Well, it says once approved, it's 1, 2, 3, 4, 5 lines
Oh, yes,
down.
okay, yeah.
Yep.
So, yeah, once approved, the monitor shall submit to the board a plan by which respondents' practice shall be monitored. So, I don't know if it might be more beneficial for us to keep it that way since it's been working for us.
Don't fix it if it's not broken.
Right. So
I would
you
just
guys have the
suggest
final-
if you're going to change it back, I would just suggest saying that you change it back to that once approved, the monitor shall submit to the board or its designee a plan by which respondents' practice shall be monitored, and the board or its designee shall approve such plan. And that kind of, I think, gives you, as the probation monitor, some flexibility in if the plan doesn't exactly work for you, or if they don't do it on a template or if they do it on the template, that you have that flexibility and the ultimate say as to what the plan is.
Okay. And I'm sorry, can you just reiterate what, and the board or its designee has to
Okay. Once approved, the monitor shall submit to the board or its designee a plan by which respondents' practice shall be monitored. And then you could say something like,
The board or its designee shall approve such a plan?
yes, the board or its
So just
designee.
one long sentence.
It could
Okay.
be one long sentence, it could be 2 sentences. I don't know, I have a hard time with grammar when I'm not looking at it, so.
Okay, that's a good suggestion, yeah.
So then strike the, Kelsey, you're saying strike the actual, strike.
Proposed
Yeah,
language.
strike that proposed section on page 9. Upon approval for the monitor, da-da-da-da.
That's at the board's discretion because there is other language in there, like 15 days. I don't know if the board wants to keep something like that, where we have a time limit that the monitor, the plan has to be submitted. If the board wants it to be 15 days.
So it's already 15 days, correct?
It is not. There is no day limit in the current language.
What would staff?
Oh, the proposed language does have a 15-day.
Okay.
I'm sorry.
Okay, gotcha.
Yeah.
Okay.
Well, actually, the 15 days, I thought it just relates to receipt.
you're right.
Yeah, receipt
right.
of us having the monitoring
Right.
plan, the board.
So that really wouldn't come into play now.
Yeah.
So yes, to strike that paragraph.
Well,
that whole
except for
paragraph.
maybe the first line, right? Oh, no, yeah, no, the whole thing. You're right.
And then insert those 2 sentences.
Board members were clear on this change?
Yeah.
The other suggestion I would make that's in this one, but I would also make it as a global change, would be every time it says, it happens on page 9 in the first paragraph, 1, 2, 3, 4 lines down. And it's talking about a licensed acupuncturist whose license is valid, in good standing, and not disciplined. I might suggest changing it to active, because that's language that is actually in your act, rather than valid. There might be
Where is that language currently, on page 9?
well, I think it's throughout. I circled it in a couple places,
Okay.
so my suggestion would be to make a global change.
Right.
Got
That
it.
every time that it says a valid license, that you change it to an active license.
Got it.
Okay.
Okay.
Sure.
Do we need to specify clear and active?
Yeah, you can say clear and active. I mean, in good standing and not disciplined by the board means clear. But yeah, you can't have an active license if you haven't renewed and been in compliance with all your renewals. You can't, it becomes expired or whatever. So really designating the status of the license, I think, is helpful, because you can't have, like I said, if you're not in compliance with, it's not just discipline. If you're not in compliance with your CEs, you can't renew, you become expired, so you don't have an active license.
Got
So.
it. Okay. Makes sense.
Okay. So we'll make that change.
So instead of valid,
Yeah.
we're changing the word from valid to clear and active, right? Okay. And that's a global change throughout the document.
Yes.
Got it.
Okay.
Yes.
Okay, good.
Mr. Chair?
Yeah, we're going to public comment at the very end.
So I have to wait till the very end of all of this?
Right. Right? Considering the way it's going?
Yeah, however you want to address it.
Yeah.
I got a question that came in, the president of California Acupuncture Association is monitoring. He just sent me a question, said, could you ask this question on my behalf?
Sure,
So
that's
it's
fine.
on this item, so I didn't want
Yeah,
to wait until.
that's fine.
Okay.
2 minutes.
I'm representing Michael Fox from the California Acupuncture Association, who sends in from Texas. He's visiting his mom, who's not well. So a new grad can be a probation monitor for a 20-year practitioner. ACOM requires a technical supervisor to have 3 years' experience when supervising in the clinic. Could you expand on that to make sure he's clear in understanding that? That was just a comment and question.
5 years.
We have 5 for clinic supervisors. I think we need to differentiate between a clinic supervisor and a probation monitor, or a
Practice
billing
monitor.
monitor.
This is
or
for
practice
probation.
monitor. Yeah.
Okay, that's why I didn't have the difference.
This is for probation that we're discussing.
I got it.
But the question still is the probation monitor, like just a new graduate, to monitor someone right now, probation who's practiced 20 years. If that's the question I hear?
Correct.
Yeah, so
So the length of practice that the monitor has?
currently
Yeah,
we
like
don't
the mount.
have, we
Right.
don't have it, right?
A new
We have-
practitioner could be monitoring a 20-year
Gotcha.
practitioner. So that was his question, because his
No, the
understanding was that
recommendation
ACOM
was that there is
requires
no
a.
limit on experience, is
Current,
what she was
Currently,
saying,
yeah,
yeah.
currently,
No limit, but is there a minimum?
So
There's
we
a
do have a
minimum-
vetting
minimum.
process at the board for selecting these monitors, and we do thoroughly investigate the status of the suggested monitors. So we have leeway in selecting who we want and whether or not we feel as the board's designee, they're competent to perform that action. And we have had that leeway until now as well. And not experienced any problems.
Right.
Yeah.
I'm asking someone else's question,
Certainly,
trying to
certainly.
help.
No,
out,
that's
because
perfect.
He represents a lot of people, so.
No, makes sense.
Okay.
Thanks,
thank
Neil.
you.
Yeah, thank you.
Christine, so we're okay?
Yeah.
Okay, board members, we're going to move forward. So to page 4. Any items?
hold on, where
back to the other thing. Hold
Yeah.
on. A lot of pages going on here.
Sorry.
It's okay.
Page 4 is 5 through 9.
Yeah, we got it. Hold on, restrictions. Okay, I was just rereading number 7, and I remember going over that, but it's specifically to make sure that the protect the public by prohibiting respondent from providing a certain technique or modality that he or she lacks skill in or deviates from the standard. So now I get it. It's fine. Yeah, making sure that that person goes and gets training in the lack of skill in that area, and making sure we have that restriction of practice or training of that practice, correct?
Well, this particular number 7 doesn't deal with requiring them to get the additional training,
Okay.
but we would do that for
Right.
somebody in that situation. This just deals with restricting them from that particular practice.
Right, whatever they violated.
Yeah, like maybe if it was an out-of-scope
Right.
practice they were doing.
Got it, okay. Just wanted to clarify. Thanks. Okay, I'm okay with that page.
Okay. Everybody okay? Yep. Okay, page 5 has several items. So it's 10 through 13. So 11, 12, and 13 were highlighted. Were one of the 3 highlighted amendments. So focus on those. Are there any questions, comments?
I think I'm good.
I do have one.
Kelsey? Brian?
So on number 12, abstain from drugs and alcohol and submit to tests and samples. Because in California, marijuana is now legal and may be taken out of the codes that are referenced, it might be prudent for the board to have abstain from drugs, alcohol, and marijuana and submit to tests and samples if the board so chooses. Essentially to treat marijuana like alcohol. It's something that is legal, but it's not something that we want you to be engaging in while you're on probation.
Practitioners, what do you guys think?
I agree with that. For probation's sakes, yes.
What if it's for
Sure, come on up.
It's prescription or something.
If there's a prescription,
I'm speaking for myself, Neil, I'm not representing anybody. If it's for medical purposes, so if you have insomnia and you can't sleep at night and you take medical marijuana for sleep, then that's not going to affect your judgment or your, it's through a physician's referral. So is there an exemption there? So you're taking medication under supervision of a physician, so how would the board respond to that?
so I guess there is the exception that if you're taking it for a prescription and it was legitimately issued and is necessary as part of treatment for the respondent, that would be okay. I'd probably change, I would probably add the word referral with prescription there, because technically in California, their referrals are not prescriptions. So that's, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 lines down in number 12, where it says, upon request of the board, or it says, any respondent shall provide documentation from the licensed practitioner that the prescription, and I would say, or
Wait,
referral.
which one are you reading? In the packet or?
12.
Oh, I know it's 12.
Oh, sorry, I'm reading from the actual
Guidelines.
disciplinary guidelines, I'm sorry.
Page 13 of the proposed guidelines.
Yeah.
Page 13.
Sorry, those are where my notes are, so.
That's okay, just refresh us, so we're going to page 13?
Yeah, so it's page 13, it is item 12. And it's right after that strike-through language in it. It says, upon request of the board or its designee, respondent shall provide documentation from the licensed practitioner that the prescription, and then I would insert the word or referral for the drug was legitimately issued and is a necessary part of the treatment of the respondent.
Got it. Question, do we need to specify referral for marijuana? Are there other types of referrals that might pull into a loophole there?
I don't know if I would probably do that so quick to narrow it down to marijuana because the laws are changing and that nomenclature might also change. So I'd say keep it maybe kind of wide scale, like a referral, because they might change that to a prescription soon. At least we have prescription, and if we have referral, at least it's in there. You know what I'm saying?
The other thing with guidelines is that you have the option to tailor them always, so if there is a case that, you know,
Modify it a little bit.
yeah, we can fine tune it going forward, but I can also look into that, and if I do see an issue with it, I can bring it to the board's attention.
And it's page 13 right now?
Yes.
Right.
12:9.
I apologize, I wrote my notes in
Can you read which line? I just want to make sure I know where I am.
Yeah, so it's right after that strike-through
Yep.
language, and
Yep.
it says upon request of the
I
board.
got it.
Okay.
Where are you
Okay.
putting in?
It'll be documentation from the licensed practitioner that the prescription or
Or
referral for the drug was legitimately issued and is a necessary part of the treatment of the respondent.
Okay.
Should we put also necessary part of the medical treatment for the respondent? Because the treatment, we don't also want that to be confused with maybe the treatment that we're giving them, or?
Yeah, you can.
Prescription is already a treatment.
Oh, right. The board's not giving a treatment, the board is doing a probationary terms.
Right.
So I
And
don't
that
think
this
there's no,
prescription or referral was for a necessary part of their medical treatment. So they were saying they have a condition, this is what's being referred to them to treat that said condition. Boom, boom. You know what I'm saying, just so, because they might find loopholes around that.
clarity's good.
Yeah,
Yeah.
I agree.
What happened for this, it's you know what, you need a medical treatment if you're gonna be on probation.
We good there? Okay.
Okay, so we're gonna be adding in after the word alcohol in condition number 12. We have alcohol underlined, we're gonna be adding in marijuana, comma, correct?
Right.
Okay?
In the title
We
as
should,
well.
yeah, thank you.
In the title as well, okay. And then we'll add in prescription, and then we'll add in the words or referral, as Kelsey just described. And then on the next line, a necessary part of the, add in the word medical treatment, as Coradino just laid out. And then on the last sentence, any possession or use of alcohol, we'll add in the word marijuana, comma, and then go back to controlled substances or associated with da-da-da. Is that what we want?
I like that myself. Everyone else is
Good.
good. That's good.
Okay. Great. So we'll move to number 13, which is another highlighted item. Coursework.
Change it from 3 years to 1 year.
How are we looking, board members?
Good.
We're okay? Okay, we'll move to page 6. And we will look at 14 and 15. Are we okay?
Yes.
Yeah.
Kelsey? Yes. Okay. So, nothing else on page 6. Page 7 is 19 through 25, and one of the highlighted items is 25, probation monitoring costs. So we have a few pages remaining. The highlighted items are completed, but we'll go through each page. So page 8, board members, any items?
Good.
Clear.
Page 9.
Oh, wait, sorry.
Yep.
Are we in standard terms and conditions now?
Page 9?
In the memo.
Okay, yes, so
Page 9 of the memo.
I want to go back, sorry. I
Yeah.
would like to go back to tolling, which is, would be page
17, 18?
Wait, stick with one thing we're looking at.
we're looking at
I'm
the
looking at the
memo?
packet.
Yeah, I'm looking at the memo now.
Okay.
So page 7, sorry.
Page 7.
Page 7 on.
Gotcha.
Yeah.
Number 21.
Yeah.
21.
Yeah,
Okay,
21.
It was page 7. Okay, got it.
Is also page 18 in the document if we're playing that game too.
Gotcha.
So, what I would like to offer there, some boards still impose certain conditions while you're tolling, such as still submitting quarterly reports, maintaining an active license. So I don't see those there, so I wanted to offer that it is something to think about. That while somebody is out of state tolling and they should be on probation with the board, should they maintain an active license? Should they be required to renew? Should they be required to complete their CEs? All those things. Should they be required then to still submit to their probation monitor a quarterly report? I don't know how the board handles it currently.
They're told from every condition. The only thing that is an exclusion from the proposed language here is cost recovery would not be told. But you're correct, no other conditions are excluded, so they wouldn't have to comply with anything else other than pay their costs.
So if someone were to take a leave of absence from the state to go to another state because a family member is sick and they're out of practice in California for 2 years,
Yeah.
and then they want to come back, they don't have to make those 2-year CEUs catch up on that, or do any of the regulatory things we would have to do to keep our license?
In terms of their probation, they're not required to, but in terms of their license, like it's kind of dealt separately.
Okay.
They would need to stay up on their license if they didn't want to have it lapse and cancel.
Gotcha.
And then if they cancel, then their probation period, I mean, it's just ended because we no longer have jurisdiction over their license.
So if they're on probation and leave the state,
Uh-huh.
there's no requirement for them to go through to renew their license or CEs?
Oh,
That's what the
no.
question was.
Yeah.
Correct.
And so I
No.
guess the harm there is that you have somebody who tolls and then they let their license expire or cancel, and then they no longer are licensed by the board, but yet they're supposed to be on probation. So if they come back, then they're having to reapply for a new license. Meanwhile, you have this license that's on probation. So
right.
it can cause some issue.
So what would you suggest?
I would probably suggest keeping an active license at least. That way you still have jurisdiction over them the entire time that they're on. So what happens if they go to another state and they're told here and they commit a crime of some sorts and you don't never know about it? I guess if they were still active you would know about it. Is that right?
Well, through the new regulation, they're supposed to report it to us within 30 days as far as,
but
yeah.
Let's say that they don't report it necessarily, but you would still have them in the system, right?
Yes, yeah, I mean, they're live scanned, so we would get subsequent arrests and notifications about that.
If their license has lapsed, though, you wouldn't, right?
Correct, because then we have to notify DOJ that we are no longer interested and purge
Right.
them from it.
But
So-
that's not just for lapse, that has to be canceled when we issue the
Yeah,
NOI.
it has to be canceled, not just
Okay.
expired.
3 years of non-activity on their license.
Okay. So I don't know that this does come up a lot for you guys. I'm just offering it as to think about it, that you may want to require that if somebody is tolling out of state, because they may be practicing in another state when they're supposed to be on probation in California, that you may want to require that, but you may not. It's
Okay.
completely up to you.
Gotcha.
Do you have any ideas roundabout what's the average probation, we're putting practitioners on that can't practice, that are in this stage tolling?
Oh, that are currently told. So of the probations that we have, I believe we have like 3 that are told and are out of state. There is one that, yes, has been told for a couple years.
Why is he tolling for so long?
But he's been out of the country that long.
And tolling means that he's been on probation, his just license is kind of on hold then right now?
Not his license. His probation is on hold. Because he's out of state. Yeah. So I mean,
when he returns,
then it picks up where it comes back. And now, if his license cancels out, because we don't really have any, it's the same requirement it is on any licensee. You want to keep it current if you want to, come back to, continue practicing. But if, he's not deciding to come back, then yeah, we don't have any jurisdiction to require him to get that license to current status. So it isn't a bad idea. It probably would be a good idea.
I would agree.
To have them maintain an active license.
Yeah. And if they do not, when we put a clause in there, then obviously.
If they don't, then it's a violation of probation.
Right. Yeah, it's a good idea.
Yeah.
We not also add if your license is canceled and you reapply, you must satisfy your previous probation's terms before coming to clear active license?
I don't know, that would be a Kelsey question.
Wouldn't that be considered clear?
Yeah, so that's
normal,
right, so that's if they, okay, let me think this one through. So you're saying if they have, let's say they toll for 5 years or so after 3 years under your statute, right, then that becomes a canceled license.
Sure.
So they have to reapply. So then that's technically a new application.
Mm-hmm.
You've taken, I'd have to do a little bit of an analysis on this because you've taken a disciplinary action on a different license. And now they're applying for a new license. So I don't know how due process attaches, without having to do a little bit more research on how due process would attach to that. Would you have to treat it as a fresh start? Or I guess what you could probably do is then put them on a suspended license, a conditional probational license.
Probational license, yes.
But again, you're still filling out not an accusation, but a
Statement of issues.
Statement of issues.
Yeah, we would probably deny them on the basis of having a prior discipline issued by us.
Right. But you'd probably have
right?
to specify to give them notice that if they ever did apply, that this still, like in when they voluntarily surrender their license,
Yeah,
right? We have
exactly.
a clause that says you do that by a stipulated agreement, and you have a clause that says, should you ever reapply to the board, this is disciplinary action is going to be used against you or can be used against you, and so you've given them notice. So if there's some sort of notice written in there, I think it would probably be okay.
And that's what I was thinking of, because some people might just toll and then cancel their license and like, yay, I'm free, I'm going to reapply for a license.
So yeah, so it is, and you run that risk with people who voluntarily surrender their license in lieu of having to carry out their probation. That's kind of the nature of discipline, unfortunately. So yeah,
Okay.
I think you can handle it in various ways.
Would you suggest we wait and do more research on this before, or are we okay with just having them maintain an active license?
I think that it gets handled if you have them maintain an active license, and then the only way that they don't is if they do a voluntary surrender, and again, that's by a stipulated agreement, so those things would be in there. If you do want to wait on it and give me some time to research it, I'm fairly confident that giving them a notice would probably work out.
Okay, I probably edge on the idea of being more cautious. So why don't we go ahead and make the change to include an active license, but at the same time doing more research? Because like you said, we can change this. We can change this.
Yeah, I mean it's there is a property right attached to a license, and so when you're applying to a new license, you have less of a property right. But again, yeah, so it's just it's really I'd have to look into that. Sorry.
My question is, do we want to, like we do with the cost recovery being an exclusion to not being told, do we want to put that they need to maintain a valid license during the time they're told in the tolling condition, or make it an exception as part of the condition number 29 on page 19, maintenance of a valid license, that they would, tolling is not an exception to this, or similar to.
Maintain an active current license board, include any period of toll probation.
Oh, it already has it.
Okay.
It's
So
actually already in there.
Oh, it's already in there.
I would probably add it to both, just so that
Okay.
there's no questions. So it sounds like you guys already have it in the
Okay.
maintain
We already
valid
thought of that.
license. So why not put it in the tolling
Okay.
one as well?
Same with the cost recovery, you probably want to include that in the
Yes,
tolling
yes.
condition? Okay.
I mean, I just don't see a problem with making those glaringly clear.
Right.
You're gonna have to keep an active license,
Right.
you're gonna have to pay cost recovery. So, if that deters you from tolling, you're aware of it.
Gotcha.
Yeah.
Okay.
Okay, so we're going to go ahead and, Jamie,
Yep.
under condition 21, tolling for out-of-state practice, we're just going to add in the words, respondent must maintain a clear and active license. Respondent must maintain a clear and active license during tolling period. What, I'm
Can we just work with the same sentence?
wordsmithing, basically.
Respondent shall at all times maintain an active current license with the board, including any period of suspension.
Oh, yeah, just mirror the same.
Yeah.
Okay.
Okay.
So, Jamie, board, are we
Yep.
okay with that? So that will be moved into, condition number 21 and condition number 23.
Right.
Correct? Okay.
Okay. Yeah. Okay, board member. So we were on page 9 before we switch back. So any questions or comments for page 9?
Good on my end, clear.
Seeing none, I will go to page 10.
Oh, I don't know where I hold on, sorry. Then my next question is on license surrender, 26. Did we pass that already? Sorry.
Yeah.
No, I think
Okay.
it's the,
Yeah, that's on page 8 of the memo.
Yeah.
yeah, we did.
Okay, sorry. So my only one there is, again, so adding the cost recovery part to that. Part 2.
Number 26.
License surrender.
Page 19 on the.
Right.
Some boards put that they still have to pay cost recovery, even if they surrender. That doesn't necessarily mean that the board is going to be able to collect it, but at least it's there. You give them notice. And if the board does have a mechanism to collect it, even though technically they're not a licensee anymore and we don't have full jurisdiction over them, if there is a mechanism, then the board can collect it.
Gotcha. Okay. You okay, Christine?
Yeah, I was just wondering if we already had it in the cost recovery, just making sure that's not the case.
Yeah, there.
Okay, no, we don't seem to.
Okay,
Okay.
board members, back to page 10. Questions or comments?
I got the gist of it.
Seeing none. Last page, page 11, items 30, yeah, there's 5 items there, page 11. Ben?
One of the earlier ones that we had amended was to include the clear and active license. I'm wondering if we should go back to that and have it just reflect the same language used in 29. that maintain an active current license with the board.
Active and current instead of active and valid?
Just so we have the same language throughout the document.
Okay, so instead of active and clear and active, we want to use active and current.
Okay.
So,
I had the global change was going to be changed from valid to clear and active.
Right,
Is that
yeah,
okay?
yeah, we got
Oh,
it.
clear
Yeah,
and
yeah.
So clear and active is what we're going to
Right.
stick with, okay.
The only thing with that is, and I haven't thought this all the way through before I'm saying it, but you know that then prohibits licensees from putting their license on inactive status, and I don't know if that necessarily is a problem with them being on probation and having an inactive license, especially if it's like a probation where there's not a lot of actual practice-related conditions. I don't know if that's such a problem.
Well, in our licensing system, in our license tracking system, if a person has a clear and inactive, it says valid inactive. That's what our licensing
Well,
system actually says.
Right, sometimes the terminology of what your system says is not what the statutes say. So.
We have it, it's in I think it's a reg and statute, inactive versus active.
So you do have an inactive reg. So
Yeah.
let me take a look at that quickly. Because again, so these are, again, fluid, so they don't have to apply across the board. So if you did have a circumstance where somebody had a very minor, infraction, you wouldn't necessarily have to apply that term.
This one's a standard one.
Right, but even standard
Oh,
terms.
right,
are,
and if it's a stiff,
are fluid.
okay.
Do you remember the?
Yeah,
399.489.1. In our code of
In our
regulations, very, very last page, page 49.
Okay.
In our law regulations.
Also, Kelsey, in Business and Professions Code 4935, where we talk about like unlicensed practice, somebody who is considered unlicensed or unlawful practice is somebody who does not hold a current and valid license. So we do use the term valid there.
Okay.
Jeez, can we go back and change it now?
Sorry.
Because the general BMP discusses active licenses versus inactive licenses versus retired licenses.
Mm-hmm.
cancel.
Yeah, and then there's canceled, but then there's also.
I think.
Or we put active and valid licenses.
I think in my experience with the term valid, it typically means a clear license, no discipline, as well as current.
Sure.
So, but the active and inactive is sort of something separate.
Right.
But the valid just covers the fact that it's current. They're up on their fees or up on their CEUs, and then also that there's been no discipline taken on them. Valid. That's what was my understanding. And enforcement, that's how we kind of use it, and DOI and everything.
That was the proposed change.
Yeah.
Proposed change, but maybe we'll keep it.
I don't know.
Go back to
It's really, I don't know.
So you do have this part where it says the inactive status of any license shall not deprive the board of its authority to institute or continue a disciplinary proceeding against a licensee on any ground provided by law, blah, 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 blah. But I'm wondering if you would want somebody who's on probation status to be able to be inactive.
Well, it seems like they'd be getting out of their probation, yeah.
Right, so that's,
Well, we still have jurisdiction over their license. And like I said, there are some instances where, actually there's a lot of cases where we have people where they just have decided not to practice during the time that they're on probation. And they're keeping their license current. They're not putting it on an active status. That's just a choice they've made, and it's not necessarily a problem. In fact, it just promotes public protection even more so. Because they're not in practice.
For that time they're on probation.
Right, for that time they're on
not
probation.
rehabilitated by the time they come back out of probation. That's my concern. We're not.
That's true, yeah, because they didn't have that time to be monitored. You're right, like if they're in practice and they have a practice monitor. So that might, yeah, that's something to consider.
I think that's something to consider. Your point is good because
Yeah.
I understand your point, but during probation, they did something to break the law.
Turn it on.
Sorry. I think it's a good point because in some ways, yes, during that time, they're not breaking any further laws, but the fact that they're on probation means that they did break law. And as far as our board is concerned, I think it's important to what Ben is saying to make sure they are being proactive within that time period, and that we do have jurisdiction during that time period too. So if they're inactive, then we don't have jurisdiction.
No, we do. We still have the jurisdiction. It's just that those kinds of probationary conditions that relate to their practice are kind of like moot. Like it's yeah.
Standstill.
It stands still. Yeah,
like
exactly.
A stagnant thing. And what Ben is saying is that we don't want to be in a stagnant place. We want to make sure that they're being proactive about their licensure and
right. No, that is a good
right?
point.
And
so
if-
I would go with that. I would go with that because the whole point of us correcting them and rehabilitating them is during that probationary period. Like, get the training or, take care of it so that when you're out of probation, you can go back to active status. So I would agree with that.
Okay.
They have to work for it.
Kelsey,
They have to work for it.
Sorry, I'm looking up the inactive statute very quickly. It's the general BNP code, so I don't have it in front of me. So I'm looking it up. So sorry, just bear with me. I just want to make sure that it doesn't say anything like they don't have to do anything. I don't know. I just wanted to see what the parameters of it are.
I mean, ultimately, if I may comment during that period, we're going to be able to create additional requirements saying, okay, you had bad record keeping, you're going to be taking record keeping classes. But by saying that they have to stay active, they have to be a professional. And we're not looking to punish them. We're looking for them to be competent practitioners, ensuring the safety.
Yeah.
I agree. I mean, 100% on that. Yeah.
So has that changed from what we were just discussing? Keep it as active, keep it as valid?
Keep it active. Valid is what we're still working out.
So clear and active? The mark, is that what we
Yeah,
want to change it to?
I think you could probably, since it is in your Act 2, I think it's probably okay either way.
Clear and active.
But, yeah. So the only thing,
Okay, so we're going to keep, just before we go further with this inactive, we're going to keep clear and active. That's going to be our global change. Is that what the board wants to do?
Okay.
Okay.
Thanks.
Clear and active.
On the same page.
so, yeah, so in the authority, the statute where you get the authority for the inactive license does require that it needs to be renewed, but that they don't have to do CEs, basically. So,
They don't have to continue their CE use?
need not require, yeah, holder of an inactive license need not comply with any continuing education requirement.
You're saying-
Yeah, we want to be them.
Right. So I think your guys' discussion about rehabilitation is very valid, and that you would, you could even, sorry, Christine's gonna kill me over there. You could even put that tolling is not necessarily an out of state, but if you're out of practice, as well, so that people don't necessarily have to practice, but they still have to maintain an active license, but it could be tolling. Because you have some people who move out of state and practice, but you have some people who move out of state and don't practice. You could also incorporate under tolling people who are in state but are not actually practicing anymore. But that might get tricky because then it's like a complete ban on practicing. So I just had this actually discussion with a different board because in their profession, some work for schools, and so they can have really limited times. So it was like people were throwing out like a number of 24 hours per month or something like that. So it does kind of get tricky in terms of that. So, but I guess my recommendation would probably be to have them maintain the active license for that rehabilitation factor. But it's at the board's discretion.
And I think more specific cases are going to occur as the profession grows and, gets bigger. So when you're dealing with other boards that might be wider, these are going to come up. So I don't mind putting in, we don't have to do it now. Like you said, it's fluid, so we can add it in down the road. But we're probably going to have to deal with some of those issues down the road.
And that's, the thing about the disciplinary guidelines, which are kind of nice, is that they are guidelines. They can be deviated from. When your staff is negotiating a stipulated agreement, those are considerations that they can make, and they're going to remember these conversations. And that we do want to have a little bit of fluidity to them, but we do want to keep updating them. I know it's like an arduous task, but as these situations, you can't contemplate every situation that's going to occur for every single probationer, as Christine can attest to, because there are going to be things that you just cannot anticipate. So, yeah.
Yeah.
Okay.
I think we keep it the way we're saying it, and if some situation like Kelsey just mentioned happens, then you'll remember that conversation, you'll incorporate best as can until we have to change it, because we need the expansion of the languaging. But so far, I think we're okay.
Sounds good.
Okay, I think we're clear on that issue.
Yeah.
Okay,
All right,
before we
so
start another conversation.
we're good there?
Page 11, we were on that page. Board members, any questions or comments? It is the last page.
Yeah.
We're good there.
Kelsey?
I just want to make sure that the board does go over the maximum and minimum penalties and takes a look at those and make sure that they are all in agreement on those penalty guidelines.
About 38,
Starts on page 22 of the disciplinary guidelines.
So it's not, and I don't think it's actually in the memo.
No, we didn't specify. It was too much to include. The memo's just sort of a overview. Refer to the disciplinary guidelines document in the packet, and it starts on page 22.
22?
Recommended.
The
Sorry?
strike-through, right?
Section 7.
No.
Oh, you're right,
Yeah.
22. And then a bunch
We're
of
looking at section 726
Yeah.
651.
or section
651, yeah.
651. Okay.
Harding.
Yeah.
Okay.
So these two are general B&P codes that we included.
And again, I just want to be clear that these are guidelines, so if there was a really egregious situation for, let's say, advertising, which we hadn't contemplated here today, and the ALJ is looking at it and saying, oh my gosh, I don't think that, 2-year probation is appropriate here, they may deviate, and then they would put in their order why they deviated. But what the goal is of these maximum and minimums is to tell your staff, tell ALJs, tell DAGs, this is what we think is generally appropriate in these situations. We're not trying to think of all of the different possibilities that could occur, but generally speaking, we're comfortable with this range.
Is this range pretty standard throughout other boards under advertising?
I would say so. It really depends on the profession,
Got it.
to be honest. Some professions are more egregious in their advertising than others. It really is going to depend on the board. But yeah, I would say that most of the time it's more of a minor violation. So
Okay. Because our profession has had problems with advertising.
yeah.
So I just want to make sure that for our board and for what we have dealt with in the past with, fraudulent advertising, if this is pretty in the range of acceptance.
And that's going to be the question that you guys ask yourselves is, based on what you've seen, based on, complaints the board has received, if that is generally your comfort level with the penalty. If you know as a board member you're getting advertising, proposed decisions, and you're constantly, as a board, rejecting those proposed decisions and making the penalty stiffer, then you want your guidelines to reflect that.
Right.
My issue is not that it comes to the board level. My issue is that there's so much out there and it doesn't come to the board because the board is not quite aware. But I guess as preventive measure, we want it to be firm and stern, but not over the board, so that when they see that, because there has been really extreme cases of like over the board advertising, but it doesn't get reported. So if the complaint doesn't come in, we don't get to see it. But I see it all the time.
So I would.
So I'm just trying to.
Just back to the, we want to really focus our discussion on the penalties here.
Right. That's my point.
Yeah, so again, it really depends on what you've seen and what you're comfortable with, what you would want an ALJ to do in most circumstances.
Great. So let's go through them then. Section 726, commission on act of sexual abuse or misconduct with a patient, maximum penalty is revocation. I think everybody would probably agree with that. Minimum penalty, revocation stay, 60-day suspension with 5 years probation. The next one, Kelsey's on page 25, correct?
Mm-hmm.
Correct. Using or possessing any controlled substance or dangerous drug or alcoholic beverage to an extent or in a manner dangerous to himself or herself or to any other person or to the public, and to an extent that such use impairs his or her ability to exchange and practice of acupuncture with safety to the public. Max penalty, revocation or denial of license. Minimum penalty, revocation stay, 30 days suspension with 3 years probation. Everyone okay?
Yes.
Okay. Next one, section 4955B, conviction of a crime substantially related to the practice of acupuncture. Maximum penalty, revocation or denial or of license. Minimum penalty, revocation, stay, 30 days suspension with 3 years probation. Seems like we all agree.
Yep.
Next one is section 495C, false or misleading advertising. Minimum penalty, revocation stayed with 2 years probation. Hearing no comment. Section 4955D, aiding or abetting or violating or conspiring to violate the terms of this chapter or any board regulation. Maximum penalty, revocation or denial of a license. Minimum penalty, revocation stayed with 3 years probation with the following conditions.
Go back to the
Which one?
misleading advertising. How come there's no maximum penalty?
Is that because this is a repeat infraction? Kelsey? Yeah, there's no max penalty. There's only a minimum.
4955C.
Yeah, I don't know. There should probably be a max penalty.
I think actually, sorry, we had this in our act. We had the 4955C from our act in here, and then by advice, we later added the 651, which is the general BMP. And actually, we should have it mirror. It should be the same, and I'm seeing actually that it doesn't. So I would recommend that it does have the same, impose the same maximum and minimum penalties.
Thanks, Kevin, for that pickup.
So then would we be dropping the minimum penalty on 4955C?
Yeah.
Or just add
To
the
1
maximum.
year, it would be in line with 651.
Well,
Add the maximum.
Well,
Right
but
now,
also the
minimum
minimums don't
Right.
match up.
So you have two advertising statutes, and actually 651 is a lot more comprehensive. Your 4955 just says false or misleading advertising. 651 is almost a page and a half of what is false and misleading advertising, and a whole bunch of different things regarding price and regarding
Pictures.
using pictures and lots of different aspects. So I would suggest, yes, as Christine has said, to have them mirror each other, because if you're alleging one, you're going to be alleging the other, and it's going to be stemming from the exact same act.
Sure. Absolutely.
Which means the maximum penalty is the same as
As 651, right. But the minimum penalties are different.
Yeah.
So Christine is suggesting that the minimum penalty reflect what is in section 651, which is a 1 year probation.
Or can it go the other way?
The board
Can
could
it go the other way?
too.
Yeah, I mean, I don't know why,
So, so there's a whole statute on that, and I could break it down for you at a different time. But yes, there are a lot of different factors on false and misleading advertising. So, but ultimately, in either of these situations, the board is going to be alleging you had false and misleading advertising because you did X, Y, Z, and then have to charge that up and prove that. So, in an accusation or a statement of issues, both of those would probably be alleged. So they should probably hold the same penalty.
so since 4955 minimum penalty says 2 years, and on 651 the minimum penalty says 1 year, can we keep the 2-year minimum and maximum be 3 years?
You can certainly do that. That's the board's prerogative, so.
Why you want to make it 2 years as opposed to 1?
Well, I mean, there's
Said three,
one
right?
one section has 2 years, one section has
Oh.
1 year. So we want to be unison in
Right.
both, and I'm just proposing that we go with what the minimum penalty is on that section and move it over to 651.
I get that.
Just mirror it.
But why 2 years as opposed to keeping the 1? You think 1 year is too less? Not enough?
I think,
For advertising, misleading?
yeah,
What if it's just a minor infraction?
but then that's what she was saying, the ALJ, based upon the case.
Yeah, they
the
determine
case,
how
but
far they wanna go.
they can
Why
decide.
put anything then if that's the reason?
Their
But as
guidelines.
but as a
So I think
guideline,
a guideline of 1 and 2 would
as
be
a
fine.
guideline,
Are discussing whether or not to have minimum 1, maximum 2, or 2, maximum 3?
Kelsey, can they make it a range for that one? 1 to 2 years, or
I mean,
probably
you-
not?
You can make it arranged with them, that's confusing. I think it's just meant to be like, to be honest, if I'm an ALJ, here's what I'm gonna do. I'm gonna look at what the statement of issues says, or the accusation says. I'm gonna see where the violations occurred. I'm gonna look up that statute. I'm gonna go to your recommended violation guidelines, and I'm gonna look at the penalty, and I'm gonna say, okay, here's the maximum penalty, here's the minimum penalty. Where does this case fall? And then I'm gonna do something either in between, or right on the maximum, right on the minimum, whatever the facts allege. So it's really just a way to communicate to ALJs, to DAGs, to your staff, what you think is appropriate. And so if it's minor, which a lot of advertising may be minor, and you think that 1 year probation is sufficient for a minor violation, then I would have that be the
Yeah.
minimum. If you do not think that 1 year probation is sufficient for a minor violation of advertising, and you want it to be 2, then I would recommend to do that. So, because you are really, while, again, they're guidelines and they are fluid and you can change them, most of the time, these numbers are gonna be used.
Right.
So, just keep that in mind.
So going back to Jeannie, I would agree with the advertising, correct? Why don't we just mirror it, 2 years max, 1 year probation?
That's what I'm saying. But Jeannie was saying make it 2 years probation for both of them, and I'm saying for a minimum, just keep it 1 year, I think that's fine. 1 year, and if it's a steep offense, then they can raise it to 2 years or 5 years, they have the freedom to do that, but I think for a minor, first-time offense for advertising, I think 1 year.
but I mean,
probation.
I'm not sure if we're talking exactly about first time. For first time offenses, I'm fine with that. It's just that I've personally seen cases over the years, even with big organizations, falsely advertising with false names, and it's been a problem, but it never came to the board level. But it's out there very pervasively, in all different languages. So we may not come across it as English speaking, but in other languages, there's a lot of pervasive false languaging that I've seen over the years. And so I'm only saying it because the 2 years already exist in one section of the law, and another section is 1. So I was just saying, okay, if minimum penalty in that section is 2 years, then just move it over to that. Only to show that we're taking this seriously, that false advertisement has been an issue over the years for our community. So So I'm not attached either way, but if you move it, if you make it a little bit more stern, then I'm hoping that they will be less likely to break some serious advertising.
I think it's the purpose saying misleading and compare with the advertising. I haven't had some kind of difference. So that's why the minimum penalty is 2 years instead of 1 year in another section of the advertising. Because in here specifically say misleading, which had an intention to making it. That's why you get a hefty penalty. On the other hand, you're advertising by negligence. It's not intention. I think that's the difference.
So 651, though, both, 651 actually uses even more language. It uses false, misleading, misrepresenting, kind of in any way, shape, or form. So it does have the same intent, I believe.
And that would include negligence in 651?
Yeah, I could look it up.
I mean, we could suggest a minimum of 1 and a maximum of 3, and then allow the ALJ to determine if you want to be able to be harder or require more rehabilitation.
Yeah, I'm okay with that. I just, because this is an area where I see over and over again in different newspapers of other languages, and it's pervasive. And since we're here, and since this, I wouldn't have even noticed it if this discrepancy didn't occur. But if it's minimum of 1 and maximum of 3, I'm okay with that.
Okay. Other members?
I would agree. Okay.
That's fine.
Are staff okay?
So to summarize, we're going to basically, in 4955C, we're going to remove our existing little minimum penalty, whatnot. We're going to insert the language from 651 with a maximum penalty revocation state 3 years probation, minimum penalty revocation state 1 year probation. Is that correct? And then both 651 and 4955C, that is what it will say. Is that
1
what the board-
minimum, 3 maximum.
Correct. Is that what the board's
That's
desires?
fine.
Okay.
Sure.
Very
Also
good.
note that the optional conditions are different. Advertising for 651 only has optional conditions 13, whereas for 4955C it has 13 and 14.
So we can make that
That's-
uniform,
Yeah, it's coursework and community service.
13 and 14.
So include 14 for 651?
1.
Okay.
Yeah.
We're including 14 and 651
As an
Yeah.
optional condition.
as an optional condition? Okay, all right, very good.
So now everything is uniform, 16 through 30 is uniform, okay, good. All right,
Okay. Moving forward.
thank you.
Section 4955E, failing to follow infection control guidelines, maximum revocation or denial of license, minimum revocation stayed with 3 years probation, depending on nature and severity of violation. Questions, concerns? Good. Okay. Section 4955F, the use of threats or harassment against licensed patients. Maximum penalty, revocation of denial of license, minimum penalty, revocation stayed with 3 years. Pretty tough. Pretty tough one. Section 495H, disciplinary action taken by any public agency. Max penalty, revocation of denial of license, minimum penalty, revocation stayed with 3 years probation. Seeing no comments. Section 955I, action or conduct that warrants a denial of license, max penalty, revocation or denial of license, minimum penalty, revocation stayed with 3 years probation. Moving along, section 495J, violation of any law or local ordinance on business premises, max penalty, revocation or denial of license, minimum penalty, revocation stayed with 3 years probation. Violation fraud section, we are still on 27. Section 49551A, securing a license by fraud or deceit. Revocation is the only suitable penalty in as so much as the license would not have been issued but for the fraud or deception. If the fraud is substantiated prior to issuance of the license or registration, then denial of the application is the only suitable penalty. Max penalty, revocation or denial of license. Minimum penalty, revocation stayed with 3 years probation. Okay, moving along. Section 49551B, C, and D. Any act involving fraud, dishonesty, or corruption as an acupuncturist, max penalty, revocation, or denial of license. Minimum penalty, revocation stayed, 60-day suspension with 30 years probation. 3 years. 3 years probation. I'm sorry. Jeez, we're really tough.
Throw the book at them.
We don't like that.
We're not sleeping.
That was a slip.
Come on, again, it's almost 4 o'clock. Okay, so section 4955.1E, failing to maintain adequate and accurate records, repeated acts. Max penalty is revocation or denial of license. Minimum penalty, revocation stayed with 2 years probation. Any concerns? Moving down, page 28, section 4955.2A, gross negligence. Max penalty, revocation or denial of license. Minimum penalty, revocation stayed 60 days with 3 years probation. Moving along, section 4955.2B, repeated negligent acts, max penalty, revocation or denial of license. Minimum penalty, revocation stayed, 90-day suspension with 3 years probation. Sure, Kip.
Counsel, as a gross negligent, okay, you had a penalty, just negligent, do the board had an imposed penalty on it?
Or just negligence?
Yeah.
So I think,
Yeah.
deviation, yeah, I don't think that there is one in here.
It's not in the statute.
Yeah, there's not, it's only gross negligence,
Mhm.
right?
Mm-hmm.
So yeah, these are just what the statute allows, so there isn't just one for negligence.
Okay.
Yeah.
Okay. Moving forward, section 4955.2C, incompetence, maximum penalty, revocation or denial of license. Minimum penalty, revocation stayed, 90 days of suspension.
That might be
Oh, right. With 3 years probation, excuse me.
Incompetence.
Yeah.
Negligent is-
Because, yeah, your statute, so the statute is named disciplinary action for negligence or incompetence, but then it really doesn't have negligence. It has only gross negligence, repeated negligent acts, or incompetence. So incompetence probably.
Incompetence?
Yeah.
I don't think so.
Yeah, it's not quite the same, but that's just how your statute's
Yeah.
written.
Yeah.
Okay. Kelsey, are we complete in terms of what we need to review? Any more suggestions?
Just take a brief look at the next couple of pages.
Board members, go ahead and look through the next couple pages. So.
Make sure that there isn't anything there.
Members of the public, we're looking at page 30, starting there.
So on 30, there's really nothing because it's just changing board and 4959, which is your code section. It's just updating those things. But just the language for probation orders, recommended language for cost recovery, demonstrations of rehabilitation, evidence of mitigation, evidence of aggravation, which these are all pretty straightforward, but I just want to make sure that the board has had the time to look them over and approve them.
I hate to open a can of worms here, but on page 31, in cases in which petitioners for reinstatement have not practiced acupuncture in the state of California for an extended period of time, they must retake the licensing exam before reinstatement. Do we want to be more specific?
Yeah, where's that again, Ben? I'm sorry.
Sorry, that would be second to last paragraph on page 31, the
yeah,
first
for sure.
sentence.
Should define that time.
Right. We just say extended time, and
Yeah.
ultimately, that does leave it up to the board, but that is pretty fuzzy. I mean, do we want, like,
No, let's be more detailed about it.
do we want 5 years?
So that's basically what we're saying is if someone leaves the state
Right.
while they're under probation and their license lapse, and they haven't practiced for X amount of years, when do we find that time suffice that they have to retake the exam before they practice in California?
This is for reinstatements that are going to be on probation. So like when people come before the board, petition for reinstatement, and then you guys make the decision to place them, issue them a new license, or excuse me, reinstate their license and place them on probation, this is how that order would read. So it'd be up to you guys to determine what the extended length of time would be if they were out of.
So
What is the-
you would be seeing this on a case-by-case basis every single time because the board has to sit in on petition for reinstatement hearings.
It's like the one we saw just a couple
Yeah,
of-
we had one in San Diego.
Yeah.
Mhm. Exactly. So you sit with the ALJ or you sit alone. And so you are writing the proposed decision essentially. And so it's at your discretion at that point to put in that term if you feel like they've been out of practice for a certain amount of time. And it may vary or it may always be the same, but you can make it more specific.
But then
I
we're
would
gonna
probably
be-
say,
Yeah.
you're gonna see it on a case-by-case
Okay.
basis
Keep it-
anyway. You want a little bit of fluidity, yeah.
Okay,
Okay,
Thanks, you.
good, thank you, Ben. Okay,
okay.
you guys are awesome.
I had a-
I'm sorry.
This has come up for us, page 33. The petitioner should provide details regarding rehabilitation that include letters of reference from professors or colleges within the field of acupuncture. I know, Jeannie, we've seen this, right? Getting letters of recommendations from individuals on their own letterhead. So, does this line here indicate, well, is there anything we can do with this?
What are you trying to avoid?
Well, people writing their own letters of rec, basically.
Oh,
Yeah.
of course.
Yeah. Because I know we had a big discussion about this before.
I
So,
remember hearing about that.
at the hearing, the petitioner or respondent has the right to present their evidence as they would like to. This is more just a guideline, you're right, to say, this is what we would like to see if you're trying to show rehabilitation. These are the things that we're going to take into consideration. And obviously, you're going to, part of proposed decision-making is weighing evidence and assigning the correct weight to various pieces of evidence. So if you have a letter that's on somebody's personal letterhead that says whatever, you're going to, as the adjudicator, as the judge, you're going to assign minimum weight to the credibility of that letter. So I don't know that you can necessarily avoid it because people are
Okay.
still going to do what they want to do. If you want to word it differently, that's certainly up to you. But
Maybe
they,
this is a
Actually, it's
situation
probably
where,
better not to do that, just see what they do,
I
we'll
just
see
know
what
that
they
we-
present to
yeah,
us, and then we.
you know,
can
you're
make
right, because it's, if they want to fall on their own
Yeah.
sword, okay.
Yeah, exactly, right.
Because this is an issue we've dealt with in the past. Okay, we're fine.
I'm right in front of that, thanks. Yep.
Give low weight to those on their own letterhead.
So, okay.
They have nerve. Okay.
and I would say too that just offer from my experience that these are what we're looking at right now. They're pretty standard throughout most boards.
Gotcha.
Most boards have something at least very similar to this. So.
We just do the case by case when it
Yeah.
comes up, and then when it's so blatant like that, the one we're talking about with Jamie, it was pretty blatant, so it was pretty obvious. Okay.
Any other comments board members, for the other items on the last 2 pages?
So Jamie, would you like to amend your motion at this time?
We need public comment?
Well, you can amend your, it depends how you want to do it. You
I'd
can-
like to go to public comment first.
Okay.
And then, so. Any public comment on what we've discussed?
In 2 minutes or less?
Do our best.
That's a heck of a lot to try to keep up with.
Fair point.
Pardon?
Trying to get you to your flight, Neil, so.
I got it, but that's a whole lot of stuff for somebody. Neil Miller, California Society for Acupuncture and Asian Medicine.
Minutes for each proposal that we discussed.
I'm not going to go through every one. I'm simply going to say that
Oh, yeah.
it's a lot to digest. There's a lot of notes that I made that are things that are somewhat not perfectly clear. And I'd like to add one. So I'll go with the one that I would like to add, that it is unprofessional conduct for anyone to direct someone else to do acupuncture. And that was written because medical doctors were directing people, but that also applies to acupuncturists. So it's unprofessional conduct, my understanding, I'm not a lawyer, but for an acupuncturist to direct someone else to do something, take out needles, put in needles, to do something else, and I have seen that happen, where they were working with a student or someone else, and they said, hey, can you run in there and put these needles in and do this, or somebody else. So I'm not making the rules or anything, but that is something that I think that we need to be as current as all other health professionals. That law does apply to us, and there's no reference to that here. That's not my main point, but
What section would that be under?
It'd be 4955 unprofessional conduct.
Say that again?
4955 unprofessional conduct. For something like that, because it's like not like real specific, like a subsection of 4955, we would rely on an expert probably, and they would let us know, was this a departure? Was this considered unprofessional conduct? And that's what we'd rely on.
if I were to summarize briefly, there's a number of things on here where someone could make innocent or not understanding the law is no excuse, but there are things that someone could do inadvertently that they might not know. It might be a language problem where you say, you know what, you're doing something wrong here, and we're going to take away your license and put you on probation for 3 years or 2 years or something. It seems a little harsh for certain things, and almost everything here has 2 years, you know, it's pretty harsh, and there's a lot of things here that aren't real clear to a practitioner. I mean, I've been practicing a long time, and I know the law. I've read the book a lot. I know them pretty well, and there's still things on here that aren't really clear. And I'll just give you an example of false advertising. If I were to advertise that I do sports acupuncture or orthopedic acupuncture, neurophysiological acupuncture, or dry needling acupuncture, am I in violation of the law? So I asked, you know, it was on the agenda, and I asked if it's in my scope of practice or if it's dry needling acupuncture, and I didn't get a real clear answer. So if I leave here today, and acupuncturists around the country are putting that on their websites and everywhere else, because if you Google sports acupuncture, all the articles are related to dry needling because the physical therapies are so pervasive in putting that out there. So in the world of social media and everything else, dry needling is part of it, and if you Google sports acupuncture, dry needling comes up. I know no less than a dozen acupuncturists in California who have added in the discussions that they've added dry needling acupuncture as part of their advertising process to try to mitigate this. And they have no knowledge of whether or not they're in violation of the law. And I used your example of neurophysiological acupuncture because it falls into the same category because it's not specifically spelled out in the statute. And that could create a huge problem for the board with cases and for practitioners and everything else. So I know that you want to adopt all of this, but I would like to take a deep breath. I mean, I have 8 pages of notes on stuff that you did, and I don't want to take up all your time going over them one by one, but as a person, I would like to...
Sorry, there will be a 45-day comment period on these. So once if the board chooses to adopt them today, and they file them with, then there will be a 45 day period where the public will have all opportunities to comment on the entirety.
Is that it will be sent out, is it 45 days from today that you approve this?
No,
Or is it
no.
45 days
There's-
from a public notice with
There's
which?
public notice, and it'll be 45 days from the public notice.
Okay,
And a lot of things we talked about is more clearly defined and explained in the actual correct writing, so that advertising
Well, no, these are
is-
disciplinary guidelines, so these are violations of the act. So, in terms of,
there's nothing that explains
understanding
most of this.
Right, and that's not the goal of this document, is to explain it. It's for when somebody has been put on probation, these are the terms and conditions that apply to them. So, what happens is that there's, an accusation or a statement of issues is filed, and that's where the meat of, if an advertising is considered to be false or misleading or misrepresent to the public in some way, shape, or form, that's where that would be. But this document is not in any way, shape, or form meant to interpret the statutes or to give guidance to say it is false advertising when X occurs or when Y occurs. It's not when A or B occurs. This is simply to say if you are found to be in violation of advertising, the minimum penalty should be this, the maximum penalty should be this, and these are the terms and the conditions that may apply to your probation if you are found to be in violation.
So is there a way to bridge that gap so that we can understand what it is? Like a quick example, 4955J, violation of any law or local ordinance on business premises. The health department in Southern California was going around to acupuncturists that sold herbs, and they came in and they were locking you down, closing you down because you needed to meet the same criteria as a restaurant. You had to have mop sinks because herbs are considered food, and you had to come up with the same standards as food, and as such, you would be in violation of a local ordinance. And getting your license taken away or 3 years probation for something that you had no clue. I mean, it cost me thousands of dollars to defend myself against this, but I had no clue. The health department showed up and said, "You sell herbs here?" And I said, "Yes." And they said, "Well, we'd like to see your permit, your mop sinks, your this, that, and the other." And I was closed down and given a fine. I mean, it was cited for being in violation of a local ordinance. So I have no clue, and it seems like extreme for me to go on probation for something I had no clue about, or something that was so minor. So I'm trying to bridge a gap and to figure out. I understand that these are the guidelines if you've been convicted, but there's got to be something that makes it easier for the practitioner to understand what you might be in violation of. Like I said, I read the rules and regulations all the time. I know them pretty damn well. But a lot of this isn't clear as to what my violation is in relationship to the business and professions rules and regulations. I don't expect you to answer it now, but I'll wait for agenda time to say that we need to have some sort of committee to look at some of these problems. And especially, as Jeannie brought out, in some of the Asian communities where there isn't a great deal of communication. And if something comes out and it doesn't come out in the different languages, you're going to see the same problems. Thank you very much.
Philip Yang from Nanstar University. This question, the first question maybe is for Jay. Like currently we're required for the updated curriculum. The requirement is it's very good. It's really make our program is more complete and get a much better education for the students. Do we have some? Do you have the corresponding reference books or guidelines for like a TCM dermatology, TCM external medicine, and TCM traumatology, and something like that? Do we have the corresponding reference books?
We're just taking public.
Yeah, just future agenda items. So if you have a question specific to Jay, you could probably email him.
Okay. The second is right now we do have the two kind of professions in the gray area. This may impact the consumers like safety issues. Like one is TCM traumatology, one is herbal medicine. Like the herbal medicine, we consider this as food in the U.S. That means if you are not licensed, but you still can make the prescription. Even someone they read the books and make the prescription to harm for their selves. This is fine, but they can. I know this is a formula. They know this is a very good recipe, and then eventually to harm to others, but there's no any responsibility. But essentially, this is to harm to the consumers. And someone says, okay, I'm good in the prescription of the herbal formula, but if they have then a problem, there's also no responsibility. So do you consider in the future to do some either regulations or reinforcement for enforcement for these professions? So is it possible to consider the future agenda issue in the?
Is that herbal enforcement?
Yeah, herbal.
Did I
Yeah,
catch that
under
right?
traumatology.
Herbal and traumatology.
Yeah.
Enforcement.
Yeah. Thank you.
Any other public comment?
Yoon Kim, Empress College. Regarding the dry needling issue, I wanted to let the board know that the Council of Colleges of Acupuncture and Oriental Medicine has done a lot of work on this issue, and we also have a white paper. So as you define your position, I recommend that you refer to that